It's been a term, I think, unlike any other in living memory, but I do think it'd be fair to describe it as a kind of a sea change in terms of both the direction of the court, but also its willingness to move quickly on certain issues where it may have been more incremental before. The issue in Bruen was the constitutionality of a somewhat unique New York law. They have this discretionary approach to concealed carry where you have to show some kind of a special need. That requirement was almost never deemed to be satisfied, particularly in New York City, and so the decision about whether you could carry would be left effectively to the whim of a local law enforcement official. And so the issue in the Bruen case was whether that permitting regime was constitutional or unconstitutional. The Supreme Court struck down New York's discretionary permitting system for concealed carry. Justice Thomas's majority opinion rejects the court's standard approach to assessing the constitutionality of freedom-restricting regulations. So instead of this tiered scrutiny or interest-balancing approach that we tend to see in other constitutional settings, Justice Thomas articulated a text, history, and tradition approach. Justice Breyer's dissent was all about policy. It really wasn't about constitutional text, and it really wasn't about the relevant history. It'd be very interesting to see how it plays out, both within the context of future Second Amendment litigation, but also whether it carries over into the court's approach to other constitutional rights. The question before the Supreme Court in the Carson v. Macon case is whether it was constitutional or unconstitutional for Maine to operate a public education program where it provided public funds to parents to educate their children in non-public schools, but it can't be a religious school. Chief Justice Roberts, in his majority opinion, said, Maine does not have to provide public funds to parents to educate their children outside of the public school system. But if it does, that needs to be done on an even-handed basis and not excluding religious schools simply because they are religious. And in his dissenting opinion, Justice Breyer argued that allowing the government to provide funding to people who then use it for religious education, as in this case, unduly heightens the potential for religious strife. That, in his view, the free exercise and establishment provisions of the First Amendment was designed to forestall. This is very much part of an ongoing dialogue and debate among the different wings of the court about what the Constitution says when it comes to government support for religion. And again, the justices are really diametrically opposed on this. West Virginia v. EPA on one level is a very complicated case, and on one level it's a very simple case. It's complicated in the sense that it involves a long history of the EPA regulating air quality. On the simple level, we understand that administrative agencies have no inherent lawmaking power. They are there to execute laws. They are there to implement policy, not to make it. Did Congress grant the EPA authority to implement this clean power generation regulation or not? In a 6-3 opinion written by the Chief Justice, the court said no. The EPA have not identified a statute that grants, with sufficient clarity and specificity, the authority to implement this enormously costly and momentous regulatory policy. That is a policy decision that needs to be made by the legislature, which can then be, at least in theory, accountable to the people for embracing that policy. The dissent by Justice Kagan is very straightforward, and she simply says, hey, I thought you guys were textualists. The Clean Air Act that the EPA invoked in this case has a sweeping grant of authority to essentially establish a kind of a best emissions practice, and that's what it did. Now, you may think that it would be a better approach for Congress to be specific in authorizing the exercise of that kind of power, but there's nothing in the Constitution that says that it has to be that way. So in effect, you guys are doing very much what you accuse us of doing, which is policy making. We should stay out of it and let the EPA do what it thinks best within the parameters of its statutory authorization as it understands those to be, to address big problems.